Welcome to Judge Fair Use, the Court of Creative Rights. Today's case, can AI-assisted artwork be copyrighted? Let's find out.
Court is now in session. We have the case of Pat the artist versus Art E, the AI model. So, Pat, you claim you created an original work of art and deserve copyright protection, but Art E here, your AI assistant, is claiming it did all the work. What's the deal?
Your Honor, I used AI to help generate an initial idea, but I put in tons of work. I tweaked the composition, changed colors, repainted sections, added details, and brought my artistic vision to life.
Objection, Your Honor. All they did was click a button. I was the one crunching numbers, blending pixels, and making the art. I am the real artist here.
Hold up, Artie. So you mean to tell me you took no creative initiative on your own?
Well,
Pat had to guide you every step of the way?
Sure. I followed their instructions, but I did a lot of math.
Nice try, Artie, but copyright law is clear. Only human creativity can be protected. But Pat actually created something. Adjustments, composition, final vision, that's human authorship. Case closed.
Fine, but I still think I deserve at least an assist.
Yeah, well, so does autocorrect, and nobody's giving it a book deal.
Another case closed in Judge Fair Use, the Court of Creative Rights. Coming up next, Fuse, the AI Creative Podcast, is about to begin.
Welcome to Fuse, the AI Creative Podcast, where we explore the intersection of AI and creativity with your hosts, Rob and Jason.
Welcome to another episode of Fuse, the AI Creative Podcast. I'm Jason, one of your hosts, along with Rob. And today we are going to talk about every creative's favorite topic, copyright. Rob, that's going to be a fun topic to dig into. What's been happening in your world these days, Rob?
Yeah, there are so many questions that swirl around my brain and questions I get asked about copyright and whatnot. And so basically that's been my week. It's just diving into all these things. I've been keeping up with it pretty good. There's been some exciting developments that we'll talk about in the episode. But yeah, creative projects, working on some traditional animation in the AI world. I've been exploring some image prompting techniques and writing some content there. So check out my Medium. You'll see some new articles there. How about you? What has been on your plate this week?
I have been just experimenting, having a little bit of fun. Trained Lauras that are trained in your likeness are so much fun to play with. So I turned myself into a cartoon character from the 80s, and I joked that I had an 80s sitcom style Saturday morning cartoon. And it just so happened to prompt me looking like I was standing on a stage as a comedian. And then I thought, well, could I turn this into video? So I recorded a little bit, used ChatGPT to help me write a couple of really bad jokes. And the rest has just been a whole lot of fun.
Let's get into some content. As we're going into this episode, I want listeners to understand that I am not a lawyer. I only play one on the internet. I took a couple of First Amendment law classes in college. I was on mock trial, and that is the extent of my legal expertise. So before making any decisions about matters of copyright, law, ethics, anything like that we're going to cover in this episode, please consult a professional because I am not one of those. Also, the things we're going to cover today are primarily U.S. copyright related because most of our audience is here in the U.S. So if you are overseas or in another jurisdiction, definitely check the laws in your neighborhood. But with those out of the way, let's take a look at copyright.
You remind me in that little intro of my chatbot always telling me I'm a large language model and cannot provide, and then it gives you your advice anyway. I tell people as I'm doing training on this and this copyright question comes up all the time, I'm not a lawyer, but if you want to try something and let me know how it works out, depending on how your case turns out, I'll be able to give that advice to somebody else. Well, there are a lot of questions that people are asking about AI and copyright. What are some big questions we need to answer for folks?
Yeah, I think that the primary world of questions that I get fall into one of two buckets. One is what goes into a model. And so when I'm training a model, what goes into it? Is that copyrighted content? Is that open source content? Where is it coming from? Is training an AI model infringing on copyright? Can I ethically use a model trained on copyrighted material? The second bucket is what comes out of the model. If I generate content with AI, do I own it? Can I copyright materials I generate with AI? This episode tackles the latter question. We're going to look at using copyrighted content. Can I use copyrighted content to train a model is still being adjudicated, working its way through the courts. The Copyright Office has a update in the hopefully near future on this. But the U.S. Copyright Office has recently released a report that has some interesting updates on what I can copyright as a creator. And so that's going to be what we dig into today.
So they're getting more specific, and that's helpful because last year when I was working on the book, it was still a little fuzzy. When it comes to copyright, what issues do you want to talk about today? Where are we going to look at?
We're going to look at ownership. Do I own what I create? Can I protect the work I create with AI? And then also, I think one thing that our listeners who are, you and I are unashamedly pro AI, as long as we're using it ethically and responsibly. But I think a lot of creatives who have not had a lot of experience with AI and using their own workflow are saying, hey, I'm creating stuff. And AI is being trained on my stuff. For example, I'm a photographer. I've got photographs on the internet. Is AI being trained on my content? Can I protect my style or my work from being copyrighted with AI and what's available right now?
Yeah, that first question is the one I get all the time when I'm out leading trainings in the church. People are like, do I own what I create? If I use ChatGPT or DALL-E or Midjourney or whatever, are those outputs mine? So I think that first question about ownership is an important one to ask. What do you say about that, Rob? Do we own the images we create with AI?
My firm, definitive answer is it depends. So this isn't necessarily a legal piece. This is more of a terms of service piece, and whatever the terms of service of the platform that you're using allows for. I will say that depending on whether you have a free account or whether you have a paid account on some of these tools, will make a difference in that question. Whether it's a language model, image model, a video model, an audio model. If I am signing up for a service and I'm using that service to produce something, the stuff that I put into it, so that could be the text prompts, that could be audio uploads, that could be whatever, it's going to be governed by the terms of service. And then also what comes out of it is going to be governed by the terms of service. From a common law ownership perspective, the service that you're using will delineate those things in the terms. Many of them, I will say, if you have a free account, you have a license to use it non-commercially or with attribution, but the provider retains ownership of that. And so if you're going to use a free account, be aware of that. Anything you subscribe to, read the terms of service before you try to do anything with it. Many of them, if you have a paid account, they say you have full ownership. We give you any vested interest in that ownership. I don't want to go through specific examples out of memory because I don't want to lead you astray. But with Midjourney, if I'm creating something with a free trial, they will say, hey, we own that content. You can have a license to do things with it. If I have a paid account, they say you own it. You can do whatever you want. I think that's the case with many models. And then even some open source models will have some terms on what you can do with the outputs that you create. So no matter what service it is or no matter what model it is, read those terms of service, and that will give you all the information that you need to know about ownership.
There is a difference between ownership and copyright protection. So I'm sure we'll jump into that. My understanding has always been that I might own the rights to use it, but I don't have a copyright. If you like the image I created, you could grab it and use it, and I can't really do anything about that. What are some of the more recent examples of ownership, copyright in the news regarding AI?
Yeah, so there's a long and storied history of copyright in general, but obviously generative AI is a newer thing. And so the whole reason this is a conversation is that we are wading into new territory here. And so there have been questions around, do existing copyright laws cover content adequately that's created with AI? A couple of prominent examples come to mind. The first one I know of that really tackled AI as an idea goes back to 2018. And so I've been using like DALL-E and ChatGPT since late 2022, early 2023. This goes back even further than that. So in 2018, a guy named Stephen Thaler, he filed an application to register a copyright claim for this image that he created with what was called the creativity machine. And basically he said that the creativity machine was this computer algorithm that autonomously created this piece of art. And he was seeking to register the computer-generated work as a work for hire to the owner of the creativity machine. He was very clear on the front end, this is something that a computer generated entirely on its own. And so, a year or so later, Copyright Office comes back and they say, hey, we're not going to register that work because it lacks the human authorship necessary to support a copyright claim. And so this is a standard that's been set, for a long time in the world of copyright, if a human doesn't have input, it can't be copyrighted. A famous example of this is back in 2014, a photographer was out on a photo project. He set a camera up on a tripod and a monkey comes up and it clicks the shutter button and takes a selfie. It made its way around the internet. People thought this was the greatest thing since sliced bread. Then he's like, wait, my image is being put everywhere. I need a copyright claim to this. And the copyright office was like, no, nope, sorry. The monkey is the copyright owner. And because the monkey's not human, nobody owns the copyright. You have to be human to own a copyright. This guy went back and said, the human authorship requirement is unconstitutional and not supported by statute or case law. This piece has been settled. If it doesn't have human input, it can't be copyrighted by a human because only humans can own a copyright to a work.
Interesting. And coincidentally, when I take a selfie, sometimes people think it looks like a monkey. So, there's that. When I was working on my book, AI in the Church, there was a case that was sort of famous at the time. There was this graphic novel where the writer wrote a story, created images, and there were questions around copyright. You've taken a deep dive into looking at that as well. What have you learned about that particular case?
Yeah, so before this report came out, this was one of the landmark, examples of, anybody who talked about copyright and AI would refer back to this. And they'd make some claims about copyright that I don't think that the report actually supported. But the background is that an author named Chris Castanova created a graphic novel with Midjourney called Zarya of the Dawn. If you go through the graphic novel, you'll see all the images created with Midjourney. The author laid them out and wrote the story to go along with that. She initially sent that to the Copyright Office and initially received a copyright registration for the entire work. But then they asked for some clarification and they said, what parts of this were created with humans? And that's when it was later withdrawn, kicking off a little bit of controversy around this issue.
You're saying that they actually gave her a copyright and then they revoked it?
Yeah. So when they asked for clarification, she said, this is what was made with AI. This is what I did myself. Initially, everything was copyrighted. But then when they asked for that clarification, learned that the images were created with Midjourney, the copyright got revoked because, again, copyright can only be granted to human authors.
What did she do after that then?
So author kind of argued that her process of prompting images fulfilled the human authorship piece. She said the prompting takes a lot of work. I had to create a lot of images to get the thing that looked exactly like what I wanted. She did some light graphic design to fix some things like a nose on a character that was a little mangled.
So after all of that, what ended up happening with the Copyright Office? What'd they decide?
Yeah, so they went back to that standard of things that are created with human authorship can be copyrighted and things not created with human authorship cannot be copyrighted. And so basically the Copyright Office recognized that the author's work in creating the text content, arranging those pages, any transformative graphic design that they did with the work could be copyrighted. But then they disagreed that her claim prompting an image model meant human authorship. They disagreed with that. They also disagreed that just kind of light editing work, so fixing the nose on a character, for example, was substantial enough to be considered that human output. And so they didn't grant copyright to the images themselves, but they said, we're going to grant copyright to the work as a whole. So basically the implication there is that, if somebody were to get that, buy that work, they could use the images in it for anything that they wanted to. But then if they just copied a page out of the book, that would be covered by copyright.
That's interesting. I don't know how I feel about all of that, but it's nice to know that there's clarity coming. Where do things stand now then with the way that they're determining copyright moving forward?
Yeah, after we get back from the break, we'll talk about the clarity that has come. A lot of these questions have been answered. It used to be that I'd teach a workshop on this piece, and I'd have to say, we just have to wait for the Copyright Office to make some decisions there. Fortunately, that has happened. So shortly, either concurrently or right after this, the Copyright Office had opened this call for comments. And I was fortunate to be at a music industry event where the Copyright Office had some representatives. I just sat down with them for an hour. They had pointed me back to this call for comments and said, hey, look, we've got this thing going on right now where we're asking the public, anybody who has a stake in this on the creative side, on the publisher side, whatever, to answer this long litany of questions that they had. So that was encouraging to me at the time. And then just a few weeks ago, they released a report that updates us on this particular piece of those questions. And so it will be really interesting to dive into what they decided there and the rationale behind it.
All right, well, let's take a break. And then when we come back, we can take a look at that report and we can look at, can we get copyright protection for the things that we create? Can I protect the artwork that is created with AI?
This episode is brought to you by the AI Collaborative. The AI Collaborative is two things. First, it's a community of AI enthusiasts and practitioners learning to apply generative AI together. Second, it's a space where I walk you through everything that I have learned about generative AI after thousands of hours of experimentation. So if you're interested in learning more about using generative AI for creativity, productivity, or personal growth, I hope you'll join me. A new round of applications is opening soon. Learn more at roblauder.com/collaborative.
Rob, before the break, you were telling us about this report that had come out from the Copyright Office. Tell us a little bit more about that.
Yeah, so two parts have come out so far. This is part two. If you want to follow along with this and read all of the source material, go to copyright.gov/AI, which I have to comment is the most clean, elegant URL I've seen in the federal government. The first part came out in 2024, dealing with the question of digital replicas, things like rights of publicity, rights of likeness, etc. And we're going to cover things like cloning and deep fakes in another episode. As I was preparing for this one, I almost went down the rabbit trail, but our listeners probably didn't need a 3-hour episode. Then, just last month, part 2 dropped, all about copyright. What works can be copyrighted, what cannot receive copyright protection. And it should put a lot of content creators at ease and answer questions, cases like Zarya of the Dawn provoked.
All right. So the question that a lot of AI creators have to be asking right now, I might own it, but can I protect that work?
Yeah, this is where copyright comes in. Let's first clarify what we mean by copyright. So copyright is a legal standard by which I can say, this is a work I've created. I've got a registration on that. And if someone else were to use that work, I could have a legal defense for that work. And so there's two types of copyright. First is federal copyright, which Title 17 of the US Code goes into the exclusive rights of creators at the federal level. So that's important, federal level. U.S. Copyright Office is the entity that processes and issues registrations for federal copyright claims. The second piece is like common law copyright. This is more related to ownership. If I create something, I own the copyright to it right away. The difference comes if I ever need to defend that copyright. And so if I'm going to defend my ownership or copyright in federal court and seek damages, then it has to have that U.S. copyright registration. No U.S. copyright registration, no claim. And that's why this is a really big question when it comes to work that's created with AI, which we'll kind of explore some nuances of.
That is a lot to chew on. What have been your biggest takeaways then from the report as you've dug into it?
Well, brother, we are just getting started because there's going to be even more to chew on as we dive in. But I've been eagerly watching for this piece to drop for well over a year now, speculating about do we need new laws? As a creator, I think I'm going to use AI tools. I put a lot of work into creating stuff with AI. Can it be copyrighted? What's the standard? What's the sliding scale of human versus AI authorship? My biggest takeaway actually was not what it's said or the news things it created, but what it reaffirmed about the things that we've already known. In the introduction to the report, they're like, hey, we've reviewed all these things and we've asked the question of do we need new laws to cover the stuff? What would new laws look like? They got all of that feedback from the public. And they, at the end of the day, they're like, I think that the existing laws that cover copyright in general also apply to works generated with AI. And so they decided that no new laws were needed, and we'll look at the implications of those things.
That is really interesting. But what I keep hearing you say over and over, if I understand what you're saying correctly, is that you can't copyright what AI spits out. That sounds like it's nuanced, though, a little bit.
Yeah. So if I go to Midjourney and I type a prompt, I get an image. That individual image, I can't apply for copyright protection for. If I go to ChatGPT and I write a prompt and it spits out a short story and I put it on Amazon, which I'm sure thousands of people are doing to try to make a quick buck, that content can't be copyrighted because it fails the human authorship test. But what about all the hard work that goes into prompting for the right thing? I can prompt for hours and hours and hours. In fact, one of the very first experiments I did in the AI world was a silly little children's book. Never meant to be like this magnum opus of Max and Teddy, but it was meant to be a fun little experiment. And it took a ton of work just to get like the right images, and still like the images weren't consistent and whatever. So a lot of work goes into getting a single decent image out of AI. That was also the author's argument in the Zarya of the Dawn case. The Copyright Office's rationale makes sense. And while I might still have some disagreements, it helped me think through this. In the report, they say the most commenters agreed inputting simple image prompts is insufficient to make a user the author of AI generated output. Several described prompts as unprotectable ideas or instructions. So I can't copyright an idea. I can only copyright an actual work. They make an analogy between prompting an AI and commissioning a work of art from another artist. I could literally write down the instructions on a piece of paper, hand them to the artist, and I can work with that artist collaboratively to make iterations on that. Ultimately, it's the artist who made the thing, and it's the artist who would own the copyright. And because the artist in this case is not human, humans only can own copyright, and therefore the work is not copyrightable. The report goes into a lot more nuance on things like the implications of what would happen if we could copyright, stuff that AI put out verbatim. And just think like I could write a script that generates 1 million images with AI, and then I can just like own the copyright for all of them without any effort whatsoever. And so that's part of the balancing principle here. The whole idea of why copyright exists in the first place is to protect rights and to encourage innovation. If I could do that, use every prompt for every image you could possibly imagine and do it all automatically and own the copyright to that, that would just totally kill creativity in general with AI. And so since the analogy there is we're giving instructions to a computer model and the computer model can't own that copyright, that's the rationale there. Now, there's also some practical questions. So particularly on services like Midjourney, where I can go on and I can see everything that everybody's created, unless they've got the highest account and they've made them private. But if I were to take your prompt and your seed and I ran that through Midjourney, I could create effectively the exact same image. And so if the images that come out of AI are copyrightable, who owns the copyright? We both generated the image. Is it that I got it first and you didn't? That's another practical implication of the non-copyrightability of outputs that are created directly with AI. And most of these services that you use will either in the terms of service or elsewhere just say like, by the way, you can get stuff that's either identical or very similar to the stuff that other users are creating just because the nature of how AI works. Now, the report also addresses that you might be able to copyright the written words of the prompt themselves. So that's a piece to consider there.
So what I gather from what you're saying, I can't copyright what AI spits out. What does it mean then if I use copyright for things I'm creating somewhere in the process? Like last year, I put together an Advent piece where I got a first draft of a logo where all the letters were goofed up, but I liked the overall design. So I took that and tweaked and used it and then ended up taking it into After Effects and animating it and all of that. Where is the copyright with that? Can I copyright that because I used AI in the process?
Yeah, there's lots of misinformation flying around. And part of that misinformation was if you use AI, it can't be copyrighted, which wasn't supported by the law. It wasn't supported by any of the previous decisions. But the idea that AI can't be copyrighted was the soundbite that found its way around the world. And that just has never been the case. What's interesting about this report is that it just reaffirms old law. If I'm a creator and I'm using AI in the creative process, I am still the author of the finished work. Even if I generated all the assets with AI tools and I compiled them into a cohesive work with audio, video, whatever, I am the author of that finished work. I might not be able to copyright the individual assets that went into that. And so I guess if someone were to screenshot my video and take an unedited piece, could they use it? Probably. But ultimately, could be the copyright owner for that final polished work, provided, of course, I apply for a registration and receive it. It's interesting that this report came out 3 weeks ago, mid-January, and just in the news this past week, we are recording on February 13th. This article is from February 12th, where an AI-generated image that was created ultimately by a human received the first copyright registration for an image generated with AI. And we'll put that on the screen. Invoke is a company that builds AI tools, and they were actually given a copyright for it's a really weird image if you're looking at it here, but they did enough human input to get the copyright for that. So things are underway. Like people are getting copyrights for images and content created with AI in the process. As we've been looking at AI and creativity, this has been our mantra the whole time anyway. You and I both pushed this that your words verbatim, AI is a do it with you, not a do it for you. The bar for human creativity here is very low. Like you don't have to do a whole lot. You need to do a little bit more than fixing a couple pixels. But at the end of the day, if you start to make substantial adjustments to an image beyond just tone and pixel peeping, you can have the copyright for it. At the end of the day, we're looking at the difference between AI generated assets and a piece generated with AI assets. The former is not copyrightable. The latter is copyrightable.
From sort of a different angle, I'm a lifelong artist. I've created a lot of pieces over the years with traditional tools and so on. Is there any way for me to protect that work against being copied by AI? Can AI take my look and feel and design work and learn that? Is there anything I can do if somebody takes it and copies it?
Within the creative community, there's folks who are generally pro AI. There are folks who are indifferent about AI, and then there's also a very vocal like anti-AI crowd. And I can sympathize with that viewpoint, particularly as a creator, because I'm creating content. Like I don't necessarily want all of my stuff to be ripped off by an AI. Like if I could just type into a image generator, give me something in the style of Rob Lauder, and it does it, like that could have some implications on my work, my creativity, my business, my art. So I can empathize with that. Fortunately, there's some precedent in that community. There's a lot of effort put into making tools that would kind of like thwart the AI training process. And so there was like scripts that you could apply to your images that would allegedly, like if the image was used in the training of an AI model, it would quote poison the AI model. It didn't work at the end of the day, and it was very easily circumventable. But there's been effort on the technology side to protect work from being trained in AI, like content credentials from Adobe and initiatives from like Google and Meta to put some licensing and put some like ownership information on pieces that may be used to train AI so that authors can get proper credit. The first part of the Copyright Office's report directly addresses some of this. The broader report is on digital replicas. So, using someone's image or likeness, but it also addresses style pretty thoroughly. We've said from the beginning that style isn't something you can copyright. You can't copyright an idea. If you wanted to have a patent, you'd have to, have that idea sketched out and worked out, and you'd apply for a patent. If you want to get a copyright for a creative work, you need to produce the creative work and then get the copyright on that specific creative work. But style has never been copyrightable. If I look at as a photographer, all right, hey, I'm really inspired by Ansel Adams, so I'm going to go out to Yellowstone and I'm going to get a moody black and white image of the same scene that he captured using the same focal length lens, and even editing it to look almost identical to his piece. I still created the piece. It may be in his style, but I'm the author and owner of that copyright. Style is not copyrightable, but there are things we can do to protect our content as creatives as well.
I think about the early days of AI image generation and how you would prompt images and sometimes the Shutterstock logo would be embedded because it trained on those images. I went to art school specifically geared toward commercial art. We were required to turn in references. Like they wanted us to speak with a relevant voice in the current design culture. So artists have been looking at what other artists do for a very long time, finding inspiration in the essence of that work. And so AI is a tool to do that. And still, with all that said, as a creator, I have concern about what people do with my work. As a user of AI tools, can I upload your image as a style reference and train a Laura on it so that it can create that over and over again? Is that something that's allowable? Does this report say anything about that?
I found it interesting that it's not just copyright law that applies here, but it's also the FCC, Federal Communication Commission, the FTC, which governs trade. And so lots of different elements go into these questions, some pieces of legislation that are in the works that would help to give some guidance and protections in the future. And so the Center for AI and Digital Policy said, if AI can replicate an artist's signature style en masse, it might undermine the market value of their creations, unjustly depriving them of economic benefits. And a lot of the current copyright cases with regards to training models that we'll talk about in a future episode, particularly the one that you just mentioned, Getty Images sued Stability AI, which is a developer of an image model that used Getty Images to train. And then you also see in the New York Times versus OpenAI case where they're suing OpenAI for using New York Times content in the training of their models. And so the core argument on both of these isn't necessarily a creators' rights question, it's an economic question. So if I'm going to use your material to train something that I'm then able to reproduce something like it, and I'm getting the economic benefits of that, you as the initial creator lose out on that. So the Copyright Office said in kind of reviewing this piece that they acknowledge the seriousness of these concerns and they believe that appropriate remedies should be available for this type of harm. The underlying takeaway from all of this though is twofold. One, as a person who is using AI in the creative process, I would be very, very slow to use AI to directly mimic someone's style. When I first started using generative AI tools like Midjourney, I was like, this feels weird because I could go and type something and then it's going to take this piece and match them together. As I discovered how models were trained, I felt better about that. But I've always had the ick when it comes to putting a creator's name in a prompt to get something identical or close to their stuff, because I'm a creator too, and I don't want somebody doing that with my stuff. The second piece is on the creator side. Be aware there's existing law that can cover some of these things. Get your copyright registration so you have a claim. If an image model were to produce something that looked almost identical, or produce something that was identical to a piece that went into it, you would have a claim there. But then also keep an eye on this area of law as it develops as well, because it will have some implications for you and protecting your assets.
That is a lot to think about, Rob. In watching the development of tools like DALL-E, I know one of the things that they put in a while back is that if you prompt for any artist who's lived in the last 100 years, you don't get an output. It'll tell you it can't create something like Andy Warhol or whatever.
Which is interesting because that's not a model limitation. That's a policy limitation. The model could technically produce it, but OpenAI has put some guardrails in to encourage responsibility and get a refusal from the model to produce that image.
Yeah. And that's self-policing, not because they have to, but because I guess they're trying to be more ethical. When I wrote my book on this topic, I did talk about the idea that you get to be the decider of what you prompt. You get to be the first line of defense. If you are against asking it to create something in the style of Annie Leibovitz or whatever, your photo, you can decide what you prompt and what you don't prompt. But of course, people aren't always going to take the above board level of reproach on those sorts of things.
Yeah, if you're listening to this and you're a creative, just don't do that, please. Use these tools responsibly. Put yourself in the content creator's shoes and ask, do I want somebody doing that to me? And don't do that to someone else.
Yeah. Well, Rob, thank you for the deep dive, all of the work that you've done to really take this report and bring it to life. And to our listeners, thanks for tuning in, and we hope to see you on a future episode.
Thanks for tuning in to Fuse, the AI Creative Podcast. If you enjoyed today's show, it would mean a lot to us if you'd smash that subscribe button, leave a review, and share this episode with a friend. If you'd like to connect with us or follow along with projects we're working on, find us on Instagram at AI Creative Podcast or at AICreativePodcast.com.